I had a slightly different format in mind at this point, but I realized now we only have 20 minutes left, and then if I pursue kind of a discussion on the panel, we'll run out of time to engage you. So I decided I'd probably hold off some of the questions I had in mind to kind of stimulate more exchange of opinions from the panel and kind of like open the discussion for the audience. So any comments or questions you have, you would like? Yeah, so I see many hands, so I think it's a right to do it this way. We have a mobile mic, so is anyone, could anyone help? So is there a microphone, or does it work?
سمعت أحمد النتشن نقابة المحامين الفلسطينيين القدس فلسطين أو كرر القدس فلسطين. سمعت من خلال الترجمة كلمة السيدة عنان قالت تقدم الخدمة الأصلية للسكان تقدم الخدمة للسكان الأصليين كررت مرتين من خلال الترجمة. فإذا كانت صحة الترجمة فأنا جدا أنتقد هذا الكلام وأستهجن ما قالته السيدة عنان لأنها تعرف من هم السكان الأصليين. وأنا في تعريفي عن نفسي قلت أحمد النتشي من القدس فلسطين. وعلى سبيل الفرض الساقط فإن حتى لو صحت هذه الفرضية فإن هذه الكلمة تعني بما تعنيه أن للسكان الأصليين فهناك تمييز عنصري. وشكرا. هذه ملاحظة فقط.
So let me start from here. Yes, you can use your mic there, and then I'll just move this way. Yes.
I just want to ask my question to the speaker from Malawi. Are they a full-time paralegals you have under your organization, or is a community-based that basically they have their own profession like farmers or anything else? Thank you.
Please. Yes.
Thanks, Zaza. I'm Azif from Isle of Nepal. I have a few questions maybe concerned with Professor A and Dr. So actually I have hundreds of examples, so how the early access made the change in a Japanese life. Just we told our example that we are only the Isle of in Nepal who are giving legal representation from the arrest time, and we had appealed against the remand order in the 422 cases, where we get habeas corpus granted in 248 cases, and so you can assume that the 50%, more than 50% remand order was collapsed by the higher court, and the detainees were released. So after that, what is happened? We have no any mechanism to the public defender lawyer have the access to the police detention center. So when we filed habeas corpus, then police stopped our lawyer to visit to meet with the detainees. So maybe this question with it. So what will be the strategy will be developed to solve this kind of problem? Maybe the question with the doctor, which agency of government, like the ministry, because the ministry is the finance, provide the finance to legal aid, or the Attorney General Office, or the Bar Association, or the court, which agency is responsible or has an obligation to ensure that the detainees have a lawyer from the time of the arrest? So this is my two questions, and the last recently the gentleman at the last has presented. Yes, as he mentioned that the paralegal scheme is like an awareness program, and he aware about how to get the bail, how to detainees can be released as soon as possible. My question to him that what will be happen if he found there is the person is not remanded within the time, and what he assist or come, what will be the proper further steps after that? These are three my questions. Thank you.
Thank you. And gentleman next to you. Yes, please.
I am Abdul Latif Yusufzai from Pakistan. My question is that from all the learned speakers, it was stated that the right to fair trial starts from the moment a suspect or accused is taken into custody by police or law enforcing agency. And it was stated that the fair trial the fair trial includes that the accused person shall be given legal aid facility the moment he was either taken into custody or he was being suspected of any offense. Regarding that, my question is whether this thing is applied in any Asian country or for that matter in subcontinent, because in our constitution, Article 10A provides a fair trial for the accused person. But the fair trial concept in our country is that when he is taken into custody or he has been indicted in a criminal case, only then he has been provided this facility. Before that, this facility is not being provided. So I would just like to know that in subcontinent or for that matter in Asia, whether any country is doing this, that the moment an accused person is taken into custody by the law enforcing agency, he has straight away been provided the legal aid.
Thank you.
I'm from the Public Defense Office of Argentina. My question is in general for all the panel, and it's regarding guideline 3 of the United Nations principles. I'm going to quote this because you don't have to know it, but point B says that states should introduce measures to prohibit, in absence of any compelling circumstances, any interview of a person by the police in the absence of a lawyer, unless the person gives his or her informed and voluntary consent to a lawyer's presence, and to establish mechanisms for verifying the voluntary nature of the person's consent. So on this point of the United Nations rules, this guideline, I'm a little bit scared of this in the absence of compelling circumstances. I really don't agree with this exception. I know that these are general provisions for the whole world, but I don't think there should be an exception to this, so I'm afraid of that. And on the other hand, as it's and another thing that, as the Professor Lloyd Cape stated about the European Court of Human Rights standards, and also in the Inter-American Court in our continent of human rights, has said severally that there is no exception to the prohibition of, according to the American Convention of Human Rights, to the provision. So I think this exception would be in some way like back or behind the international standards. And on the other hand, I think we should develop, and probably would be okay to discuss, and then in the conclusions of this conference, to know more or say more about what would be those mechanisms for verifying the voluntary nature of the person's consent, not having a lawyer on police, because I think that's important.
Yes. Thank you, Mary.
First, if I may, just to thank on behalf of UNOBC to all the speakers, but especially to Professor Ed Cape, who is the lead author of the handbook, and also to Clifford Masiska, because we actually, UNOBC and PASI, published a handbook on access to legal aid in Africa that is also available here. And one paragraph on paralegals' work in police station was actually the seed to the idea for this handbook. So thank you all very much. And now for my question. I was actually very interested in both what Isadora and Clifford were saying about providing assistance before the lawyers come in. And my question is, how do you then, you said, Isadora, that 97% are entitled to public defender's assistance. And you also mentioned about lawyers picking up the case in trial. How do you make sure that there is appropriate coordination, and how do you build those partnerships between paralegals or NGOs working at that early access stage and public defenders' offices or other formal providers of legal aid to ensure that the case actually proceeds efficiently?
Thank you, Rosa. This is Sunil Pokhel from Naval Bar Association. I have the panelist number 2 and panelist number 5. My observation regarding if I can pronounce properly or not. Libby McVeigh and Mr. Simon Koroma. I will probably answer Mrs. Simon Koroma's 2 questions during my observation. Yes, it's a very important that early access to criminal justice is the base of the criminal justice system when it is started, and it is a part and parcel of the fair trial. There's a trial, pre-trial process we are talking about. And one of the panelists make observation that maybe it's a less priority of the lawyer to go to the police custody rather in the court. Maybe in some jurisdiction it's true also, and maybe due to the access of the lawyer inside the custody may be the reason of the priority. But the fundamental reason of the early access, denial of early access to criminal justice is, in my observation, is what type of justice system you're in your country, in your court. It is more or less depend on the justice system that base, particularly in the bail hearing, on the confession-based statement. Because in our jurisdiction, and I have some sort of knowledge about some jurisdiction, bail hearing of the accused person is based on the statement which he or she has confessed in the custody. What investigation authority or maybe the prosecution, they have some sort of suspicion that if there will be the access of the lawyer to the detainee, they might know their rights and they will tell true what is the or what he has done or what he has not done. So maybe this is all about the issue of the evaluation of the evidence by the court. Once the court will ask the prosecution or investigation that if there is a confession must be corroborated by other physical evidences during the remand hearing, during the bail hearing, this problem will be solved. And what Mr. Koroma has made the question that why there is in the final stage there is a huge number of acquittal and the less there is a huge number of people waiting for the justice. Maybe this is the one of the reason, because in the bail hearing they base on the confession and they put people in the custody for the trial, and finally in the final hearing they didn't find other corroborative evidence for the confession. That's why the accused get the acquittal. Thank you very much.
Okay, so let me take one final comment or question and then we'll start answering.
I'm from the judiciary of Liberia, to be specific, the Supreme Court. Therefore, my questions are directed to Dr. Horowitz for me to get some understanding of the system there. She mentioned that the majority of the caseload there in Israel are outsourced to independent lawyers. So my first question is, how do you deal with monitoring and performance, and especially to conflict of interest? And secondly, she also mentioned that these independent lawyers are on 24-hour call. So I just want to know the impact of such a system on the budget of that country. Thank you.
Okay, thank you. So I think the 8 participants that really make comments or questions. Some are addressed to one specific person, the others are addressed to more than one. So probably maybe just we'll start with Zaza, then we'll go to add in this order. So you decide. So please answer the questions which were directed to you, as well as other questions you think were relevant to your presentation. And Hannah, just if I may, just use the right of the moderator, and then I just also ask you about just clarification on, you said that there is no right to have a lawyer during police interrogation. So you can. So how do you think this affects the confidence in the justice system when someone who is detained cannot actually have a lawyer present during interrogation, which is extremely crucial point. That's what Santos versus Petke actually really was about. Judge really declaring in Europe that this is not in line with fair trial. So how do you deal with this in Israel?
Okay, maybe I'll start with the question asked by the Honorable Liberian Justice about I'll clarify the features of our system. So we have 100 internal lawyers who handle part of our caseload, by the small portion of our caseload, and most of the work is handled by external attorneys. If I might make a side remark in this respect, an issue that came up, that raised several times throughout the conference is the relationship between the Public Defender's Office and the Bar Association. This sometimes serves as a manner in which to reach out to the Bar Association, because much of the work which the government is paying for is actually, the money is turned over to the private hands of the attorneys. So what happened actually in Israel, that the Public Defender's Office took work of defendants who were previously not represented. So it didn't take away work from the Bar Association, but it fueled more work into the market by outsourcing the work that the government decided they'll pay for. So this is one of the ways that one can consider in trying to improve relationships with the Bar Association. But the private attorneys who receive cases from our office are paid by the government, and there's strict fees, that determine how much they'll be paid for each court hearing, how much they'll be paid for preparation, etc., etc. The fees aren't extremely high if you compare them to the market, but it's often a case that lawyers take a bulk of work from the Public Defender's Office and have an additional private practice, and we don't notice any shortage of lawyers within the local market who are willing to work with us. Now, we very carefully supervise these lawyers. The task of the internal lawyers is to supervise in various manners. In the breakout session later on, I'll elaborate on the way we supervise the work, but we have different mechanisms in place to see to that they provide a quality service. You also asked about the impact of the 24 hours system on our budget. Of course, it created a certain amount of increase in the budget, but if you compare it to the system that existed just before, we anyway provided service from 7 in the morning to midnight, and so this is an additional 7 hours. And also the police don't like to work in the middle of the night if they don't have to, so it's not, that we have calls at night, but it's not a tremendous increase in work. And as the market in Israel at the moment is competitive in terms of there's a surplus of lawyers in the market at the moment, so we don't find any shortage of lawyers who are willing also to be on call in the 24-hour system. And if you recall, I mentioned earlier that there's an incentive for them to be on call, because then they get the case to continue further on. So this is a way for them to begin a case already at the stage of the interrogation. About the question that the public defender from Argentina and Zaza just now asked about our system not enabling suspects to have lawyers present during interrogation. This is an issue that from time to time arises in Israel, whether or not we should adopt such a system. The last time a discussion was held within an official committee which advises the Ministry of Justice on criminal procedure matters, the notion was rejected by the majority of the members of the committees. And the idea was that if a suspect is afforded meaningful opportunity before his investigation to consult with a lawyer and be explained his rights and gain advice, then the additional benefit of having him inside the interrogation room while being investigated is not significant if the proceedings of the interrogation are properly recorded. So the idea is that if there are other mechanisms in place which ensure that illegal means or unethical practices were adopted during the interrogation. If there are other mechanisms to ensure that, then lawyers will not have to be during interrogation. And even our Bar Association expressed sort of the fear that it would turn lawyers later on into witnesses as to what went on into investigations. It would weaken the bar associations because they don't have the capacity of spending many hours in interrogation. Our system is structured differently, and it's all a matter, you know, the suspect's rights can be safeguarded in a variety of ways. And I was talking about proper recording of the investigation. We have a very expanded case law regarding when statements made by suspects during interrogation should be struck down because of various violations. So the sense was that these different kind of safeguards can protect the same interests that having a lawyer present during interrogation protects.
So we are running out of time, so probably we'll
okay, I just
could just take one extra minute, please. Just
okay.
Any other points you want to address, and then try to go faster.
Okay, I just couldn't resist the first remark made by my friend from the Palestinian Authority. We represent hundreds of Palestinians every year, and we do not discriminate between our various clients, and we have also many Arab lawyers working both as internal lawyers and external lawyers, and I'll end it at that. Thank you.
Thank you. I'm going to come to that question from the back as well on exclusions from the right of access to a lawyer at the earliest stage. I'm afraid that the European Court jurisprudence is not as robust on that point as you might have been led to believe. And I've got the judgment in Saudis and Turkey in front of me. And it clearly says that access to a lawyer should be provided from the first interrogation of a suspect by the police, unless it is demonstrated in the light of the particular circumstances of each case that there are compelling reasons to restrict this right. But importantly, the impact of incriminating statements taken in the absence of a lawyer still remains the same, even if that exclusion applies. The other thing I have in front of me is the EU access to a lawyer directive. And this point on derogations was one that those of us involved in negotiating the directives fought to the last moment on. And sadly we lost. That there were a few compromises in this directive. And I can say that there were compelling exceptions included in the directive, and they relate, I've got it in front of me, so I'm just trying to get to the right moment just so I can be accurate. They relate to, first of all, where the suspect is in a geographically remote location and a lawyer simply cannot get there within a reasonable time, but also where there's an urgent need to avert serious adverse consequences for life and limb. And thirdly, where immediate action by the investigating authorities is imperative to prevent substantial jeopardy to criminal proceedings. So I can assure you all that we weren't happy with this compromise, and there is going to be scope over time for the interpretation of these provisions to be really hammered out in the national courts, but also in the courts of the European Union, and I'd imagine that this would be a space in an area where there should hopefully be some clearer jurisprudence in due course. The other point I was supposed to...
On that, the only kind of the conciliation maybe would be that, you know, those statements obtained that cannot be used to charge the person. So that was kind of, I think, in a title. So there is some
context. The other point was from our friend over there about this deprioritization of access, of turning up to the police station. Just to be clear, I made that point in relation to fixed fee regimes, where a lawyer will get under a legal aid system a fixed fee no matter how long the case lasts, the complexity of the case. So therefore there's decisions to be made by the lawyer as to how best to use his or her time. And sadly we see the police station work sometimes deprioritised. Or, for example, in Scotland, there's a tendency to provide advice over the telephone rather than attending in person to try and minimise the time and cost. I think that was all that was addressed to me.
Thank you. Malawi is a common law country. Then on the issue of whether you can have lawyers at a police station, our law provides that a suspect can remain silent from the time that he or she is arrested until at the end of the trial. But if you choose, because the police will have to caution you to say, hang on, Clifford, you are here, we suspect that you committed ABCD. Are you willing to talk to us? Whatever you say here, we may produce this in court against you. So it is at that point said, hang on, you cannot talk to me. I have to call my lawyer to come here. That, end of story. Then the question about Clifford, are these salaried paralegals or not? Yes, we have two sets of paralegals. The ones that I was talking about, they are salaried. The ones employed by the government of Malawi are also salaried. However, we have community paralegals who are volunteers. Why? It's because there are so many. On issues of those that have their time to be in prison has exceeded what is provided by the law. What I would advise each one of us is, please, in your system, can you try to amend your criminal procedure and evidence code so that you can have pre-trial custody time limit, so that everybody knows if it's, today you are out. It doesn't matter what has happened. You are quite right. Lawyers, paralegals, how do they work together? It is, a very important point to remember that lawyers, paralegals have to work through lawyers always. That's why they are in police stations. In case they come up with any issue which is complicated, they have to, do that through the lawyer. Which lawyers? That's the biggest question. These are public defenders. Thank you. That's it.
I think I'll just answer your question here that was addressed to me. If I understood right, you want to know how we are sure that all the detainees who did not have the means to have a private lawyer will be assisted by a public defender. Is that right?
You mentioned that you are helping them during the detention stage because they don't have access to a public defender. But what happens at the trial when they are assigned a public defender? How do you coordinate?
Yeah, we managed to assist 100% of them during the period that we were there, and then we managed to take the case to the public defender to keep going. So we are sure that they will keep handling them. But the problem is that when we are not there, because there is no way to assure that they will have any legal aid. Because as long as we just have 4 public defenders, there is none inside the facility, the detention center. There is no way to assure that they will have any legal aid up until 4 months after they are in prison.
Yes, I'll just pick up on a couple of points, given that we're coming up to the break. But there was a question from Vijay in Nepal about how do you get access to the police station, or how do you persuade the authorities to allow that or to make it law? And I suppose by any means necessary is the easy answer. But just to very, very briefly to give some examples. So in my own country, in England and Wales, the government was persuaded that this should be done. And that followed a big miscarriage of justice case, and they accepted that this was a way of trying to prevent miscarriage of justice in the future. In France, it resulted from a group of French lawyers taking a series of court actions in different courts and ultimately to the Constitutional Tribunal of France, which in effect ordered that there should be access to a lawyer in police stations. In Scotland, it resulted from a decision of the Supreme Court, and in Ireland, just 2 weeks ago, it was the Director of Public Prosecutions who ordered that the police should from now on allow lawyers into police interrogations. So even in 4 adjacent jurisdictions, we see a variety of different approaches have been necessary. Of course, I have to accept that we've been fortunate in having the European Court of Human Rights and in particular the Saldus judgment. So the question from Pakistan I'm afraid I don't know whether there are other countries in the subcontinent who treat, if you like, the trial starting at the police station. I mean, that's my expression, it's not a formal expression. But it is interesting to note that the European Court of Human Rights had to grapple with this because the European Convention referred to the right of access to a lawyer arising when a person was charged with a criminal offence. And what the European Court of Human Rights did was to develop what is called an autonomous interpretation of that, which actually applies the right from the very earliest stages of the criminal process. I suppose from now on, the authority, as far as Pakistan is concerned, will include the UN principles and guidelines, because the UN principles and guidelines, of course, they're not binding, but they make it absolutely clear that access to a lawyer at the police station stage is now regarded as a fundamental international principle. And just one final very quick point about this concern from Argentina, which I share, about compelling circumstances enabling the police to deny access to a lawyer. And I think that's already been answered, but the point I would want to add is it's absolutely imperative that the judiciary reinforce any limitations that there are on denying access, so that any ability of the police to deny access to a lawyer because of compelling circumstances needs to be interpreted very strictly indeed. I think the judiciary and indeed prosecutors have a very important role to play in ensuring that this is actually effective. Because actually, sorry, this is a final point, but I find in many countries the judiciary and indeed prosecutors in effect connive with the police to enable the police to continue to breach procedural rules. And it's absolutely imperative that they stop doing that.
Thank you. Thank you. So we ran over time, so I would like to stop here. And then I think just to come back to the main topic of our discussion, it was really said very well. It is now quoted as well by in the UN principles and guidelines. But originally, this kind of phrase was really taken from the initial kind of a document the European Union published on procedural safeguards, which really was saying that access to a lawyer and legal aid is the foundation of all other rights in the criminal justice system. And that is really the essence of it. It's not only the right on its own, but without that right, the right of information, or to know your rights, the right to remain silent, access to a case file, and all other rights that are essential to organizing effective criminal defense, and enjoy basically your rights that you have by procedural codes, by international standards, but by really implementing the practice. So those rights are really given meaning by the right of access to a lawyer, and therefore access to legal aid from the outset of the police custody. Therefore, probably every effort to really try to improve criminal justice systems, and from the perspective of fair trials, I cannot imagine that happening without really giving meaning to this right and practical realization. Unfortunately, we already have a handbook which can really help many of us to take such efforts going forward. I really would like to thank all of you, first of all the panelists, but all of you for very active participation. And thank you for joining us. And I have little gifts for our panelists for their excellent presentations. Thank you.